Good evening and welcome to tonight's webinar on Are You a Legal Landlord? I've got Polly Rivers from the Landlord University.
Good evening.
Polly writes all the content that you read and sets up all these webinars, and John Coyne from the National Landlord Association.
Good evening.
So I mean, we're in good company for lots and lots of landlord knowledge. It's a bit different, this one. We have done a quiz which a lot of you have filled in. Over 1,000 landlords filled in, so we could identify the key areas which people were getting wrong, and we've asked questions in the quiz as well, so we're going to answer some of those questions, and we'll give you some of the percentages answers of where people got the answers wrong. So the first question that we've got kind of kicks us off very nicely, doesn't it, Polly?
Well, these questions, we've had some questions come in from people from registering for this evening.
Yep.
And one of the questions that came in on the registration was from a landlord who's registered tonight called Constance. So, hello, Constance, if you're listening tonight. And she's asked, she's made a bit of a statement that I think will resonate with us all, really. She said, renting really is a minefield. How does one navigate through all the legislation and remember it all? And I think that really does kick us off perfectly tonight, as Adam said. So we've, as he mentioned, we've done a bit of a different style for tonight. So we're going to go through every question that was asked on the quiz, and hopefully John will be able to shed some light on how we should be doing it all properly.
I'm sure I will be my adequate best.
And John is a perfect person to do it. He's an advisor on the NLA helpline, and you've been you've been a landlord for a long time as well, haven't you?
20 years.
So if John can't answer these questions,
and self-managing as well, self-managing landlord.
Perfect.
Yeah.
If John can't answer them, then no one's going to be able to.
Absolutely. So let's go with the easy one first. The first question that we asked was, how often do you need to apply for a gas safety certificate at your rental property? Now, I'm sure everyone on this webinar will know the answer to that, but actually, amazingly, just over 50% of people got it wrong. So, John, can you talk us through the gas safety legislation?
Yes, the gas safety legislation requires a gas safety certificate to be carried out and done by a properly registered gas safe engineer on an annual basis.
Not a monthly basis. Nearly
not a monthly
40%
basis.
of people.
Or not whenever you feel like it.
No.
Answer to that.
Now that is annually means annually, not at the change of every tenancy. It means annually. An urban myth going about there's a grace and favour period of a month. I'm not quite sure where that came from. It does not exist. There is not. To put landlords at ease on a certain point, if the gas safety certificate expires, technically a criminal offence has been committed and they're liable to be prosecuted. However, my experience is that most councils that become aware will write a warning letter and not prosecute immediately. So if you have gone over the time, just get it done and as quickly as possible. Usually councils will only prosecute a serious and very ongoing breach of the gas safety regulations.
I think where this urban myth comes from is the MOT style ruling that's come in. Polly, do you want to take us through that?
And that's certainly that's the 2 month flexibility to get it done early, not 2 months flexibility and getting it done late, which I think is. I think a lot of people are aware that there's now the flexibility of being able to, which is being likened to an MOT. So if you, in order to avoid people having to have their gas safety certificates, gas safety checks carried out early, and therefore losing time every year to avoid running out of time, as it were, you're now able to have the check done 2 months prior to the end of your last one.
Yes.
And
maintain the date.
And maintain the date. So if you had it done, if it was due to run out on the 31st of December, you could have it done on the 31st of October, but the new one wouldn't start until the 31st of December.
Absolutely.
So basically you would have a 14-month certificate almost, but it would only run for 12.
Correct.
But that doesn't work 2 months late. You have to have it done the 2 months early.
Correct. One point I'd just like to quickly make as well is that an issue on the advice line is where there's been a breakdown in communication with the tenant will not let the landlord in to do the gas safety certificate. Now, clearly a landlord cannot force entry unless they get an injunction, whereby the police can attend and entry can be forced if there's a court injunction. As long as a landlord is seen to be doing everything they can to fulfil their obligations, so they've written letters to the tenant, they've attempted to make an appointment, they've turned up with the gas engineer, the tenant won't let them in, locks are changed, etc. As long as they're making every reasonable effort, it is a 100% defence to any claim that they haven't complied with the legislation. In fact, it wouldn't even go to court.
You've just got to build the proper paper trail.
What happens if you fail the gas safety? Did you have to put your tenants in a hotel, or do you have a time frame to get it through?
Very interesting question. Very interesting question. We have known of this sort of case, Adam, where so the gas safety engineer turns up, they've looked at it and said, this boiler is failed. We've even known them to condemn the boiler and cut the gas off. Now, clearly, the remedy depends upon the circumstances. If there's no gas in the property, then technically it could be argued the property is unfit for habitation. Clearly, there'd be no hot water. If the tenant is happy to have the landlord to temporarily put in storage heaters while a new boiler is being put into the property, then the tenancy can continue, possibly with a rent reduction for loss of amenity. Yes, it might be possible to agree to put the tenant into a hotel for a week or however long it would take. Usually, it doesn't take that long to get a competent gas engineer out and get a new boiler fixed, but clearly that would have to be done if a boiler fails the gas safety certificate. There is no right or wrong about this. Clearly, discussions will have had to be had with the tenant about where we go forward, or the tenant could be, for example, go and stay with their parents for a while or something. But it shouldn't take that long to get a new boiler.
A new boiler, or hopefully if it's just a small issue, then the gas engineer can just fix it on site and pass you.
Yes, that's correct. What often happens, and I should hold up my hand if I actually had this happen, where the gas engineers come out, they said, right, we can't pass this, so we have to close it off. It needs a new part, it's going to take a couple of days, and they close down the boiler and cut the gas off. So we've gone round with space heaters or electric heaters for the tenant temporarily and said there's going to be no hot water for a couple of days. The gas engineer turns up. The other thing, again, this is what I personally do. I'm not saying other landlords should or shouldn't do this, but if I find that's happened, I will always go around with a bottle of wine per tenant.
Absolutely.
And sometimes chocolates.
It's always a good idea.
I did that to one of the Islington properties that we've got, and the tenant said that's very good. When I was around there about a week later, they started saying, the kitchen cupboard isn't quite working, call a bottle of... I said, no, don't push it. So don't push it.
So it is important, if you do have any advisories come up on your gas safety check, that they are acted on ASAP, aren't they? And there's... it's because there is quite a hefty fine potentially from your local authority should you not do that, and you should always keep your paper trail as well to show that you've done any advisories that after do crop up.
Absolutely. The other thing I'll just quickly mention, because obviously it's a serious health and safety issue where there is a problem with gas. If a gas engineer turns up and they are properly accredited by Gas Safe, you've seen their credentials, they do the boiler and they give you the correct gas safety certificate, which you then give a copy to the tenant, etc. And there's a problem with the boiler later, or an escape of gas, the landlord is 100% in the clear, because they've brought in the expert and they're relying on that expert. They're not gas engineers themselves, so it would be an issue for the gas engineer. Okay, I should say that's extremely rare, because they could be in serious problems if they basically don't do their job properly.
The other thing I wanted to talk about on gas safety is this confusion about serving the certificate on the tenant. Now, there's a lot of people out there who don't know that that's necessary.
Yes.
Think, I've done the certificate, I'm fine.
Yeah.
And then there's a lot of people who think it has to be done within 28 days of the start of the tenancy, which is wrong.
Yeah.
The right answer is that it has to be done before the start of the tenancy.
Correct.
And the 28 days, there is a 28-day rule, but that is about when you've got a tenant in the property and you're doing the subsequent, you then have 28 days to give them the certificate.
That is correct.
Now,
yes.
the upshot of this is, if you don't do these things, then if you had to serve a Section 21 notice, it could just be thrown out of court.
Yeah, there was a recent case at the Court of Appeal where the landlord served the gas safety certificate after the tenancy agreement, and the Section 21 wasn't allowed. It's quite a controversial case, because technically it means, according to the judge at Central London County Court, that they have an assured tenancy.
There's no remedy.
There's no remedy. It was not the intention of Parliament, and that is awaiting perhaps primary legislation or secondary legislation or statutory instruments to somehow remedy that. But as things stand, the gas safety certificate should be served if a new tenant is coming in prior to the tenancy agreement being signed, or it could even be part of the tenancy agreement, because many landlords now...
Does that mean does a judge have leniency if you've got it, say, 3 days after you've served it, the start of the tenancy, and it's in date? Could the judge be lenient on that, or do they have to go with the case history?
Okay, the case was at County Court, not Court of Appeal, so a county court can abide another county court. So it's persuasive, but not technically binding. Yes, it is possible that another court in another part of the country could say, we will allow the Section 21. But because the case was heard by a judge who is an absolute expert on this and has written books such as Defending Possession Proceedings, and his status as a judge is very high on these matters, it has been stated on many legal websites that it is likely to be followed, even though it's not technically legally binding.
Yeah, and judges and the courts, they're looking. There's a lot of landlords that we are professionals, but obviously there's a lot of landlords out there that do this in addition to jobs, and it's not their only thing that they do. It's they're not professional landlords by trade. So I think the courts are looking to make sure that people are doing things correctly and take the time to find out how to do things to the letter.
That is correct. I did hear, I was at a legal seminar recently, and one of the speakers said that being a landlord today is one of the most heavily regulated businesses in the country.
Absolutely,
which is why we're all here.
Good. Well, I think that's the first question covered, and some really useful tips. Okay, so the next question was about MEES, the minimum energy efficiency standards. The question was circled around the exemption and how long the exemption is valid for, and to be honest, 87% of people got it right. So, Polly, could you talk to us a little bit about MEES and what it is and what it means for landlords?
Yeah, so MEES were introduced on the 1st of April, but they unfortunately weren't an April Fool, and it was brought into force to really encourage the private rented sector to up their game a little bit with regards to energy efficiency and make sure that landlords were doing all they could to make sure that their properties were doing the best they could with regards to efficiency. And the regulations stated that no property that wanted to start a new tenancy or renew an existing tenancy after the 1st of April 2018 could do so if they had an EPC rating of less than E, so that's F or G.
So what would happen? What would happen if you did rent a property?
They're not allowed to. There was hefty fines, and you're not allowed to do so. Okay. It's just a blanket no. So there are some exemptions, which we will go through, but in this ban will eventually extend to all tenancies, new and existing, by April 2020, and there's talk of by April 2030 that the minimum energy efficiency rating will move up to EPC level C.
So if my tenancy began in January 2018 and is below the standard, I'm all right until April,
you come to renew it.
Until I come to renew it. Okay.
At which point, if you're at F, you won't be able to.
But if it started on the 1st of June 2018 and it's under, then I'm
unless you have registered an exemption.
Okay.
And there's a few exemptions, but they're not quite as simple as possibly they might be, and they've got time limits on. So whilst you may have been able to register an exemption, it won't last forever.
So in a nutshell, what are those exemptions?
So there's 6 primary exemptions. The first one is if you've been there's a number of cost funding schemes. The main one being the Green Deal that people would possibly know the name of. And if you, as a landlord, the government expects you to be able to fund up to £2,500 worth of changes to your property to get it up to the correct rating.
So an exemption is if you're doing something about it under a scheme.
So you can apply for funding, and if you're not able to get funding and you've spent £2,500 and you're still not at that rating, you can register an exemption under the cost cap.
Okay.
So that's one, but you do have to show that you've tried to get funding and you've been denied.
And how long would that exemption?
I believe that's 5 years.
So if my application for funding is in, am I all right for now?
I think you needed to get your act together and get it done. But yes, if you've got stuff in motion, then do show that. If you've done everything you can, because there's some properties out there that will never be above any.
If you're in a conservation area,
exactly,
then there's certain things you're not allowed to do.
You can't do if you've got a thatched property. That's not going to, as you say, conservation areas. So if you've made all the possible improvements that a RICS qualified surveyor has recommended, and your property is still below a band E, that's an exemption as well. But you do have to prove that a surveyor has stated that you can't do any more. If your property is not suitable for certain types of insulation, they're specifying cavity wall insulation in this instance. So if your property can't have it, then that's an exemption that you can register. An interesting one is the consent exemption. So if your tenant says that they're not prepared to let you make the changes, or if your mortgage lender or the overall owner of the building, so if you own a property within a building that has a leaseholder that says you can't make changes, that is also relevant as well. But you do have to show any supporting evidence and correspondence to say that you've reached out to them and said that you want to make the changes and that they've said no. That one is only relevant and will only last the length of time until the tenant isn't the tenant anymore. So if the tenant moves out in a year, the exemption is then null and void, and you have to start trying to make the exemptions again, make the changes again. And I would suggest that at that point, before you then get a new tenant in, you try and up your EPC rating.
So what's the best place for me to go if I think I can have an exemption? Where's the best place for me to go for advice? Is it my local council?
I would suggest probably speak to your council, because there'll be schemes in place and they'll be able to advise on that. The NLA, I would hazard a guess, would be able to advise you on that. John's nodding.
Yes,
he's
absolutely correct.
He's definitely the man who can. So give the advice line a call or speak to your local council.
Because it's a specific thing. It's going to be about your
property.
We're giving generic advice.
It's very generic, because there's different. If you've got a property in a conservation area. I know certainly in certain parts of the country. I was at an NLA meeting actually, and this cropped up. Yeah. Believe it was up in Yorkshire, and they had it was a conservation area and they couldn't change the windows, and it was going to be a real problem for a lot of the landlords in the area. But the local council was there advising on how they could.
So maybe your issue may be one that has
the council's aware of,
tackled.
Exactly.
Yeah. So
The other things that you could do is, if the changes that you need to make to get the property over the line would reduce the market value of the property, again you need your RICS qualified surveyor to confirm that. Or if you're a brand new landlord and you've just taken over the property, you get a 6-month grace period. So prove that you've just purchased, or you've just taken over as a landlord, and you get a bit of time to get your act together and then work out what you're going to do to manage the property.
Okay, well thanks Polly. I think we'll move on to the next question, which is probably one of the most talked about and questioned subjects that we get with the Landlord University. I'm sure it's the same with you, John, and that's HMO regulations.
Yes.
It's a little bit confusing, and everyone seems to have a different
Day two.
a different opinion. So the question we asked was, when the new HMO regulations come into force in October, what is the minimum? Absolutely. What is the minimum size room you will be able to let to a single adult tenant? And the answer is 6.51 square metres, very exact. And most people got that wrong.
It is worth considering that some people might not be HMO landlords, of course.
Absolutely. Yep. But an important one, because it does have consequences. John, can you take us through some of the new HMO regulation that's happened in October?
Yes. As you've mentioned, Adam, the new room sizes will be, from the 1st of October 2018, HMO minimum room sizes are 6.51 square metres for a single person and 10.22 metres for 2 persons aged over 10 years. So that is one of the main pieces of legislation. The other piece of legislation, which is affecting many landlords, is from the 1st of October 2018, any property with 5 tenants must apply for a licence irrespective of the number of floors.
5 unrelated tenants.
Unrelated tenants that don't form a single household. So that is an issue that has been brought in that may cause problems. If a landlord already has an existing licence, it will be passported into the new legislation. Also, a landlord is covered if they make the application. So in the situation where a landlord is about to let a 5-bedroomed property and they make their application to the local authority and then they relet the property, then the landlord is covered. It will affect a number of landlords because there's numbers of properties around with 5 bedrooms and they will now become mandatory HMOs.
I think it's going to affect, especially in London.
Yeah.
And in student areas where the rule that was stopping your property being an HMO would have been the 3-storey rule. Then you're now going to have to apply for a licence. And what's the consequence if you don't?
Well, it's a breach of the HMO regulations, and technically it's a criminal offence.
It's also quite interesting to consider that the room size element, once they've got their new licence, if they're not compliant with that side of things, they're then breaching. They've got an 18-month grace period because obviously I think the government anticipated that there could be an awful lot of tenants out on their ear if it was a snap job that anyone under 6.51 square metres and they're straight out. There is an 18-month grace period for landlords to work out how they're going to cope with that situation.
Yes.
But if they don't rectify the space, if they've got a room that's under the size limits, if they don't rectify the space situation within that 18-month window, that is then a breach of the licence, a criminal offence, and the licence could be revoked. And that would cause all tenants to be in a situation.
This is measuring your room is very simple if you've got a room that's just slightly over and it's a standard room. What about things like and there's going to be lots of rooms that are on the cusp here. Then people are trying to figure out whether they can, take the skirting boards up or a bay window or even sloping. If it's a roof room, where's the cut-off point on a sloping ceiling?
The ceiling has to be higher than 1.5 metres. So
Okay.
any floor space that's below a ceiling of 1.5 metres can't be counted. So if you've got a sloping ceiling, especially if you've got rooms that are up in the eaves, if you've got a converted loft, that really does leave people in a bit of a sticky situation, because your floor space might be within the space allowed, but if you've got a sloping ceiling, then it's possible that that's not going to work. It's also worth taking into account that en-suites don't count within the room space.
Okay.
It's only space that can be used for sleeping.
Correct.
You can't have a landlord expecting a tenant to sleep in a bath.
So it's the curtilage of the bedroom, basically.
Right. So built-in wardrobes, are we going to see landlords knocking out their built-in wardrobes?
Potentially.
Yeah.
There's the window spaces, if you've got a bay window, that's fine, because that's floor space that can be used. You could put a bed in a bay window.
Well, you could, yeah.
But yeah, the en-suites and that sort of things. And we've had a question in again from someone who registered for the webinar, a lady called Judy, who asked if minimum room size is an issue, if there's no separate lounge. If there's no separate lounge, can the guidance be challenged? Unfortunately, there's no flexibility on sizes, regardless if there's a separate living space. They're literally, this is only.
So you can't say, I know my bedroom's really small,
but there's massive
I've got a
living
big
space.
big lounge. It doesn't matter.
Doesn't matter.
Okay.
And clearly there will be rooms that are on the cusp, and hopefully common sense will prevail. Because at the end of the day, the licensing authority or the individual environmental health officers have a slight discretion if it's within an inch or two, or a millimetre or two. But what it would mean if a room is failed is that room cannot then be used as a bedroom. The issue then becomes one of, well, what then if the tenants in any event move a bed into the property? And one of the guidance that I saw at a seminar on HMO legislation was to somehow make it very difficult for the tenant to do that. For example, building shelves that come out, built-in shelves or cupboards, so that a bed can't be put in there, because a landlord could potentially fall under the issue of the licence. Although obviously a defence would be, I've got 4 names on this tenancy agreement and they've just done that.
And the tenant wouldn't be allowed to use that room as a guest room or anything. There has to be no bed within the room.
No, it's quite clear that it must not be used as a bedroom. It can be used as a study room, it can be used for yoga, it can be used for whatever, but it can't be used as a bedroom.
Okay. Okay, so the next question was about GDPR, the General Data Protection Regulation, which came in May of this year, and there was a lot of noise. We went to a lot of meetings and talked to a lot of landlords about GDPR versus the Data Protection Act. And actually, what we found is that although GDPR has brought data protection to the forefront for landlords, there was procedures that landlords should have been following under the Data Protection Act, and actually most landlords weren't, and GDPR brought that to light and showed landlords what they should be doing. Now, there's the upshot of it is with GDPR is that you have to protect your tenants' data. You have to understand what data you hold, if you should be holding that data, what reason you should be holding that data, whether it's contractually or because of your statutory obligation. And by statutory obligation I mean you're required to hold your tenants' passport details because under the right to rent, and then how you can securely hold that and keep that data safe, and then if there's a breach of that data, what you should be doing. And the upshot of that is that you should write all this down in what we call a privacy policy, and then provide that privacy policy to the tenants so they understand why you have their data, under what legislation you have their data, and the procedure that you will go through should there be an issue with that data. We have done a webinar which I think Polly did, and was over an hour long, specifically about GDPR. I think the best thing to do is send us an email, or if you can find that webinar, it's on the Landlord University.
There's a whole section within the NLA's document suite
Absolutely.
about GDPR.
And that's fantastic. If you're a member, you'll be able to watch that webinar back and have the written, the write-up of what exactly you need to do, and a pro forma privacy policy which you can use going forward. So I think the best thing to do if you're worried about GDPR, and it is worth, if you don't know exactly what you're doing, it is worth going and having a read and watching that webinar either on the Landlord University or on the NLA's website. Another point I'll quickly make is that you need to be registered with the ICO. How much is that, Polly?
It's £40 a year.
£40. And everyone asks, and we do have a question from John here, do I really need to register with the
not John
ICO?
Coyne, it was
no, not John Coyne, another landlord.
Registered.
Do I really need to register? Yes, you do. Yeah. I've only got one property. Yes, you do. Do I really need to register? Yes, you do. Because we get asked this question over and over again, and people Google it, and there is places where you can find people saying, no, you don't.
You don't have to, but unfortunately...
But the answer is, yes, you do. So, right, let's move on to the next question, which was all about prescribed information, which I kind of think is one of the most basic things that we need to do as landlords, is issue the prescribed information. And it's a lot of... Because I think it's such a basic and easy admin step, I think it's a lot... one that a lot of landlords either don't know they need to do, or forget to do, or don't do properly.
People know that they need to do it, but I think the interesting thing is a lot of people don't know who they need to do it to.
Yeah, okay.
And the question that we asked was who do you need to issue prescribed information to? And we asked that whether it was the lead tenant on the tenancy agreement, the tenants and the Information Commissioner's Office. We threw that one in as a rogue. Anyone you'd carried out a right to rent check on, or the correct answer of anyone that had included a financial contribution towards the deposit. Interestingly...
So that's something that needs clarifying there. We're talking about prescribed information on the deposit.
The deposit, sorry.
So there's two sets of prescribed information, really, isn't there? There's the prescribed information with the deposit, which is very important, because if you don't do that, then you could get fined. And then there's all the prescribed information around the beginning of the tenancy as well, which is very important as well.
Yeah, and this is the question we asked around was the prescribed information surrounding the deposit. Which obviously is quite a vital step if you're going to take a deposit. And there's a lot of... Everybody knows if you take a deposit, there's paperwork that is associated with it. But evidently only 9.3% of people knew that needed to go out to anybody who made a financial contribution to the deposit.
Correct.
And so that could be the tenant, that could be the tenant's parents, their business, the council...
Absolutely.
Whoever actually contributed financially.
Not necessarily even a guarantor, because parent 1 could be the guarantor, parent 2 could have paid the deposit on the tenant's behalf.
So, John, shall we start again on prescribed information for everyone?
Yes.
And what is included in prescribed information for both the deposit and for the tenancy in general? Yeah. What do I have to do? What documents do I have to serve, and why?
Okay, the Housing Act 2004, section 212 to 217, is the part that covers the issue of the tenancy deposit regulations and rules and the law around that. It came into force on April the 6th, 2007, so it has been with us now for some time. The legislation refers to what's known as the initial requirements. The initial requirements are twofold. Number one, the deposit must be itself protected within 30 days of receipt. Now, 30 days of receipt means 30 days of receipt, not when the tenancy starts. So, if a tenant pays over the deposit 15 days before the tenancy agreement is signed, they then have 15 days after the tenancy agreement is signed to protect the deposit. But that's only the first part. The second part is, as has been said, the prescribed information must be given to anyone making a financial contribution towards the deposit, which could be the guarantors. In short, the source from which the deposit came. At the NLA, we always suggest, if in doubt about who should I give this information to, err on the side of excessive disclosure. So if you think there's 2 or 3 people that should be given it, hand it to those 2 or 3 people.
And when you say hand it to, I suppose,
right?
How do I prove if I had to go to court that I've done it?
Okay, then this is where we have the rules of evidence, where it must be shown on balance of probabilities that it has been given to the person concerned. There are a number of ways. An email would count, particularly with the read receipt. Obviously, handed it to him in person. One thing that is becoming increasingly common is a clause on the tenancy agreement where the tenant signs, where it says, in signing this tenancy agreement, the tenant agrees that the landlord has provided, and then lists the things that should have been provided.
Does that have to be signed separately, or can it?
It can be. Many landlords do it. It seems to be more common, actually, to have it signed as a separate document.
Yeah.
Although many of them do have it in their contract, where the tenant agrees. Sometimes, incidentally, the prescribed information, again, another common issue, is the prescribed information, the gas safety, the EPC, the how to rent guide, are included in the body of the tenancy.
It's a good idea.
That's becoming much more common now,
Very good idea.
particularly with letting agencies, and particularly with the complexity of proof of service. Obviously, that won't get a landlord off the hook if the guarantor should have been provided with a copy of the prescribed information. There isn't a wrong way to do it, as long as there is somehow proof of the prescribed information being given to the relevant persons concerned.
So let's just list that prescribed information again. So you've got the prescribed information on the deposit.
Yeah.
You've got your gas safety.
Yeah.
You've got your EPC.
Yes.
You've got your how to rent booklet.
Yeah.
And you've got a fully signed copy of the tenancy agreement. Have I missed anything off there?
No, I think that's everything.
Let's clarify.
What we do at Urban is we put that together in a document pack with a front sheet saying I have received all this, and get it e-signed. And then you've got the email to the tenant with all. You've also got the e-signature on it all. That's really kind of fail-safe.
I mean, there's some hefty penalties for failing to serve those documents, isn't there?
Correct. Well, with the prescribed information, the penalty for non-compliance is twofold. First of all, a Section 21 cannot actually be served. But secondly, if the tenant or the relevant person who should have received the prescribed information or is involved with the tenancy deposit legislation or the contract makes an application to a county court, the court could award 3 times the deposit back to the tenant, and the deposit to be returned as well.
And it's a real, for a lot of landlords, and I've spoken to landlords about this, they feel good about they've done everything right.
Yeah.
I've got my gas safety on time, and I've got my deposit registered. I'm doing everything right.
Yeah.
And so many of them miss this service step.
Yeah.
And could really come unstuck.
Yeah.
And yes, they are good landlords. They've done everything right, but it's just this small admin step.
Yeah.
There's case history now. We were talking about earlier with a gas safety not being served. Correct. So the gas safety was in existence on time, absolutely fine. But it wasn't served before the start of the tenancy.
Yes.
And the Section 21 was thrown out.
Yes.
It's worth noting we did the landlord checklist webinar a couple of months ago now.
Yeah.
And I believe it's all still available on the NLA website for download. But there's
and the Landlord University.
And the Landlord University, and there's a download option, and we actually put together a document that is a tick list of everything you need to follow for a standard AST to talk you through this sort of thing. And it says, have you delivered a signed tenancy agreement? Have you delivered the EPC, the gas safety? So hopefully, if you were to follow that quite simple checklist, we made it fairly simple to follow. I understood it, which was always easy to follow. And I'm not saying it's foolproof, I'm not saying it's a legal document, but it does lay it out very simply, and it's a nice, easy document to follow. And if you literally tick it off, that becomes your paper trail. And you can date it, tick it, and keep the documents with it. Use it as your cover sheet for your property.
Absolutely.
The other difficulty with the sanction for non-protection of the deposit it actually is a strict liability issue. In other words, if the deposit was taken and not protected within 30 days, and the landlord protects it at day 33, then the legislation has been breached and the tenant may apply for 3 times the deposit to be paid back. In practice, it's now becoming increasingly rare for 3 times the deposit to be awarded unless there's a clear breach where it was never protected for 3 years. Usually it will be 1 times the deposit plus the deposit. So the percentage of courts awarding 3 times is actually greatly diminished. The other difficulty will be if a landlord says, well, I've now protected. The problem is it's like being slightly pregnant or a bit dead. You have done it within 30 days or not, and the tenant can come back for up to 6 years, which is why there's a few of these no-win, no-fee solicitors walking around where 4 years ago a deposit was taken and not protected within 30 days. The landlord can still be potentially liable.
Okay. Important to get your paperwork in order.
Absolutely, yeah.
Okay. So the next question that we had was a safety one, which is obviously very important.
Yeah.
So what are the legal smoke alarm requirements for a rental property? 30% or 31.8, if to be exact, got the question right, which is worrying. So 1 on every storey.
Yeah.
Polly, do you want to talk us through the smoke alarm safety rules?
Well, again, the stats on this aren't taking into account HMOs. It was for a standard residential sort of AST property, as it were. But yeah, it's a bit concerning that people weren't 100% sure on what they should be looking at doing for a smoke alarm in a rental property. And there's been a lot of talk about how things are going to be changing, and I'm sure that legislation around smoke alarms are going to be changing in the near future. But currently, as it stands, you are legally required for a standard residential property to have a smoke alarm, a working smoke alarm on. I'm going to specify working on that. There's been a lot of stories coming out recently that people are being prosecuted because they've got alarms but they're not working, they're not tested. A smoke alarm on each storey of a residential property. The landlords in Scotland have slightly tougher regulations to abide by, and I would hazard a guess, and John may know more than I do about this, that landlords in England and Wales are likely to be...
So in Scotland it has to be hardwired?
Scotland, they have to have smoke alarms in, I believe, in every room that is lived in, on every hallway, and a heat alarm in kitchens.
Yes.
And they all have to be hardwired and interlinked.
Much more stringent in Scotland, that's correct.
But it's possible that legislation is going to be moving to England and Wales in the near future.
I would say if you're undergoing a refurb or doing some extensive work, then invest in hardwired smoke alarms. I think it's a good investment anyway.
It's never going to be a bad investment.
Exactly.
And you, as a landlord, it is your responsibility to test those smoke alarms at the start of every tenancy.
Yes.
It is then the responsibility of the tenant moving forwards to do the tests. However, it's a button that you have to push. So when you do a regular maintenance check, or if you pop in and do a gas safety check, really, but if you push the button, you can rest easy then that you know that your tenants are protected, your property is protected, and that the smoke alarm works. And if you just document that you've done the test, it's noted down, and you can rest easy knowing that everyone's safe and secure.
And that answers that. We've got a question here from Gregory. Can I certify my own smoke or heat alarms in my HMO or residential property, or do I need an expert? And so the answer is yes, of course you can self-certify. There's no difference for that in HMOs.
There is no difference. In fact, what many self-managing landlords and letting agencies do now is becoming increasingly common practice, is if a member of the maintenance staff or a plumber, gas engineer or whoever attends the property to do anything for any reason, while they are there, press the button. Just press the button and make a contemporaneous note while in the property attending the gas safety certificate. I tested all fire alarms that were found to be working.
Absolutely.
I should also, to pick up on Polly's point, one of the government websites I looked at concerning this said that with this issue, a tenant is co-liable for their own health and safety. In other words, they can't start taking out batteries.
No.
Also, a landlord cannot, in terms of disturbing quiet and enjoyment, although this is a health and safety issue for the tenant's health and safety, they can't come around and knock on the door every Friday and can I come in and do this? That would be unreasonable behaviour and disturbing of potentially of quiet enjoyment of the tenants. So there's a balance to be struck. I would say a quarterly inspection is reasonable, and again, common practice.
Okay.
Yeah.
It's also worth noting that if you're providing any furniture, or if you've got curtains that are there, that they have to comply with the furniture and furnishing safety regulations.
Yes.
So they have to be fireproofed, and not fireproof, but most furniture is now. Let's be honest, anything from IKEA or Marx's or anything like that.
It's been a long time since you could buy furniture.
Exactly, but if you've got any antiques in the property, they might not be compliant.
I can't remember the cut-off date, but if there's something it's an old stuffed chair, I think that would be used in an Agatha Christie movie before 1950, does not require. But you clearly don't get too many of those anyway. But as Polly said, nearly all of the providers now furnishings to landlords, the manufacturers have a liability to make sure they are tested as well, and obviously a landlord needs to check that the correct safety notices are on the furniture when it's installed in the property.
So with regards to safety, we've talked about smoke alarm and I suppose gas safety in this webinar. We've got a whole webinar on what you need to, like a checklist for safety. So CO alarms, furniture, the smoke alarms, Legionella, everything in a bit more detail. To be honest, for residential property, none of it is too difficult. It's fairly straightforward to follow, and as long as you're on top of it all, you'll be absolutely fine. There's going to be no surprises there. HMOs is a little bit more in depth, and we'll touch upon that in that webinar. That's on the 8th of January at 7 p.m. So that's if you're concerned about safety and you want to know a little bit more about that, that's the one to watch. Last year's safety webinar is on the Landlord University and on the NLA, but the update. And it's always good to have the most relevant and current information on these things as possible, is on the 8th of January at 7 p.m. You can already register for that. That's the emails have gone out.
One just very quick point on HMO legislation for a licensable, registrable HMO, and in terms of compliance. It is best for a landlord to make their first port of call the relevant environmental health officer for that local authority. We had a case recently where a landlord purchased something that was required to be a licensable HMO, spent a lot of money putting things in, doing things in preparation, and when the HMO came round, the officer came round and said, no, that's got to come out, that's not the correct fire door that we require, although it is a fire door, and they had to spend a lot of money undoing their work. So be guided by what they say.
That's a really good point, because we get, and I'm sure you get this on the advice line, we get so many questions on a daily basis from people saying, I've got an HMO, and then the question. And actually, we can advise, but the best person whose job it is to advise you in their area, and they will know, and also by asking them and getting proof of that answer, you're kind of covering yourself as well, because they are the person to ask. The best person is your local council. As speaking as a landlord who has licensable, registrable HMOs, I almost want to ring, because I'm first name terms with several of them, I almost want to ring them before I put a new battery in, or move it slightly to the left, if it's okay. Clearly that's an exaggeration, but the point being to liaise with them. If in doubt, ring them and get them to come around and or explain what it is, etc., etc. And also, by the way, if you again, if a landlord does ring an environmental health officer and they say yes, you can do that, at the time of that phone call, say at 2:08 p.m, I spoke to Mr. George Jackson, environmental health officer for Manchester, Fallowfield in Manchester, and he said to me in the conversation, and make a contemporaneous note of it and sign it.
Build your paper trail.
That will stand up. That is a paper trail. Because sometimes they're not able to do emails all the time. Send an email to confirm it, and you don't get it.
Use these people that they're there, they're paid to do. They're the experts, and they can give you an answer which will, if anything went wrong, would really help. Okay, so the next question we had was how long is a Section 21 valid for once it has been issued? And the answer was 6 months from the date of being served. So,
Correct.
and actually most people got that right, 85.9%. But let's talk about the answer and Section 21.
Yeah. I just one quick point I just want to make about Section 21, and this concerns sometimes an anecdote can teach as much as going through what the legislation is. This is the case where a Section 21, it's correct to say it lasts for 6 months, but we had a case where a landlord served a valid Section 21 of the tenant and went to the solicitor and said, his solicitor, and said, I've served this Section 21, is it okay? The solicitor said, no, that wasn't okay. The landlord then served another Section 21 a week later on the information given from the solicitor, who is probably now his ex-solicitor, and went to court on that Section 21. The judge said that the second Section 21 was flawed. There were errors in it. The landlord then tried to say, but I've got this other one that I served early which was correct. The law on it is that a second Section 21 overrules the first one. And in this case, unfortunately, the correct one was served, and the NLA went through it in detail with him and looked at both documents. The first one was served 100% correctly, without a problem. The second one, on the advice of the solicitor, who I say is probably now his ex-solicitor, was incorrect, but that was the one he went to court on, and the judge ruled that the first one was correct, but the second one is the only one valid, because that therefore overrules the first one, which was correct. And the judge actually even said, to make further salt into the wound, the first one was actually correct, which we knew anyway. So just be mindful of the fact that a second Section 21 would overrule the first one. It's only the last signed document, which by the way means, should a landlord, and again this does crop up, I've served the Section 21, I have made a mistake, what can I do? Answer, serve a second one, but obviously add on the 2 months date, so it continues for the 2 months between date of service and date of when the tenant is required to leave the property.
So that's good advice, thanks John. What is, there's been some changes I think very, very recently. What the changes about? How did that affect us? Polly?
Well, they came into force yesterday, actually, so they are very, very recent. They've made it easier, actually. So it's about really the paperwork that you have to serve. They've simplified the process.
So there's no in-depth change to the regulation.
No, it's not.
It's an admin point, really,
yeah.
isn't it?
It's brought everybody in line. It was initially previously there was there was a number of forms that you could serve a Section 21 on. The main one that most people served a Section 21 on was the Form 6A, and that's the one that most people would be most familiar with, because it's the one that most of us used, unless you had an assured tenancy that started way back when, in which case there was all sorts of other forms that you had to use, and that's now been scrapped.
Yes.
So no matter when your tenancy started, even if it started in 1980, if you then wanted to regain possession of your property using a Section 21, you use Form 6A, no matter when it starts. So any landlord with an AST or an insured tenancy or a periodic tenancy in England or Wales wanting to evict.
Can I stop you there quickly? Yeah. They've made something simpler.
They have.
Fantastic.
I know. Yeah. It's surprising. This is why I think a lot of people are quite confused by it, because it doesn't make sense. And I wrote a big article on this for the Landlord University, and I have to say I did read the legislation a few times and go, hey, that does seem quite a good idea.
How many times do you get asked on the advice line, what form do I need to use?
We do. What as Polly said, it has been simplified. Prior to
I'm glad John
the first,
clarified that. I have to say.
prior to the 1st of October 2018, well, let me just backtrack. On the 1st of October 2015, the new rules came in on the Section 21 under the part of the Deregulation Act that came into force then, covering Section 21. So between the 1st of October and the 2015 and the 30th of September 2018, landlords had a choice whereby tenancies before 1st of October 2015, they could have used the old Section 21. And there were two types. There was the 21(1)(b) and the 21(4)(a). So they could have been used. What we were advising our landlord members at all times to just use the 6A anyway, because strange as this may seem, judges occasionally get the law wrong, and we did have a couple of issues where cases were adjourned where a judge said, well, just a moment, isn't there a new 6A? Even though the old one was correctly served according to the legislation, and we said, just do the new one anyway. Now, from the 1st of October 2018, that choice has now gone, and it's the Form 6A or the Form 6A. I hope I got the fact across that it should be the Form 6A and nothing else.
6A.
Yeah, 6A.
Good.
Yeah.
Well, it's nice to see. Let's hope that signs of things to come in this industry.
Yeah.
Sadly, probably not.
Yeah.
Okay, so let's move on to the next question. How much notice do you have to give your tenant before you enter the property for a routine check? Now, 18% of people got this right, 24 hours. And you know what? This is another little bit of a cause for confusion where landlords put in the contract about notice to enter the property, and that there's that thought there that because you've given that notice, you're allowed to enter the property. That isn't the case, is it?
It's not the case. That's quite right, Adam. Sorry, the reason I'm laughing is I've just looking at some of the response. 4.7% said no notice.
Yeah.
So they can just turn up at 3 a.m. and walk in the door.
That is a worry, but unfortunately
39.4% are willing to give 36 hours notice, though.
Sure, that's true.
There's a lot of people out there
that's true.
that are giving a lot of time.
That's true. So the notice is not a notice where you can just give the 24-hour notice and enter without consent. There must be positive consent from the tenant. I have to say, one of the issues that I've personally experienced, and there is a solution to this as well, is that, so we've got four tenants. Now, they are jointly and severally liable. If you've received permission from one tenant, be it the lead tenant or any tenant, they say you may come into the property, the landlord has received permission from everybody. And what we've had happen is, so one of our tenants says, look, we're going to come round and fix the boiler, do the tap, whatever. And of course the other tenants aren't told by the tenant that gave the permission. And we did have a case where one of our plumbers phoned up in a slight state of high excitement when he said, I walked in, there's a couple of ladies walking around with very little clothes on in the property, because the gentleman that we spoke to had not told the two ladies concerned. But so what is the solution to this? So it's clearly embarrassing. I mean, we were okay within the rules because we had had consent. Many landlords now form a WhatsApp group. So the question is asked, yes, you may enter the property, and that goes to everybody knows, and that is one way around it, modern technology.
Does it have to be in writing?
No, it doesn't have to be in writing. And you don't even really need to give 24 hours notice. I've got a group of tenants, just true anecdote, a group of tenants in Tottenham, well, they've now left, unfortunately, but they were very friendly, got on really, really well. And I'll sometimes be walking around Tottenham on a Saturday near the property, and I think, where can I go for a free slice of cake and a cup of coffee on a Saturday afternoon? So I knock on the door, hello lads, is it all right, just popping by? Yeah, John, come in, sit down, slice of cake, say, oh thanks, yeah, lovely, use the loo, great. So if you knock on the door and they say come in, you don't need, people think, the tenant says, well, you can come round in an hour. Oh no, I've got to give 24 hours. No, you don't. If the tenant says, you just come round in 5 minutes. You can come round in 5 minutes.
Yeah,
if
you don't have to be.
Don't have to.
Hours, yeah.
But you have to allow them the option.
You have to give them the option. So there must be positive consent from one of the tenants, preferably in writing, but not necessarily. I've very often I'm on the phone. Is it okay if we come round? Yes. You've got a fun conversation to say.
But not every night on their way home from work.
No, obviously not. So as long as you get consent to
and
enter.
actually, that's a very good idea. I'm very impressed with your technology skills. A WhatsApp group with your tenants is a very good idea.
I have to say, I was given that by a course I took at the NLA with one of the tenants, one of the landlord delegates actually said, I do a WhatsApp group, and a few others gone, well, that's really interesting. And she showed me.
And WhatsApp is a free app that you can download on any Android or iPhone. And basically, it's like group texting.
It's group texting,
and it makes it easier for tenants. Also, if they need to send you a photo, it makes it easier for them just to sort of ping you the photo.
This is the boiler showing F70 or F whatever it is.
This is the water pouring down the wall.
Yeah, this is the water pouring down. We've actually had that as well. Yeah, we've had that water pouring down the road. We said, look, turn off the, turn it off and we come around and leaky pipe. We've had that. Yeah.
And is there any instances when you can enter without consent?
Yes. If there is, again, obvious example. So landlord's walking along, he's got a couple of properties along the street, he's walking past on his way to another property, and he's walking past the one he's not had an appointment to visit, and he sees water coming through the door. You can enter without consent in terms of emergency, or if you reasonably believe there's some sort of emergency, you think there's a gas leak, you want to turn off the gas. So landlord in those instances can enter, or if life and limb, they feel life and limb is
and be careful then, it really does have to be an emergency, you can smell gas, you can, don't try and enter the property and use an emergency as an excuse. There has to be a believable emergency there.
What if your tenants continue to deny you access?
Right. Well, clearly, rightly or wrongly, tenants do have two enshrined rights, which is the right to quiet enjoyment and the right to exclude all others from the property, including the landlord or the landlord's agent. So if it's a question that comes up quite regularly in the advice line, I want to enter the property to do a gas safety certificate, or it's the end of the tenancy and I want to show people around. The tenant says you can't come in. Our advice is, if you've asked several times that you cannot come in, the debate has now finished.
It's their property.
Cannot go in.
It's their property essentially. Their custody.
Basically, yes.
And you signed that over to them within that agreement.
But what you can do is this, and this is a kind of little known nuance in the law. So if you put into a contract that in the last month of the tenancy, the landlord, the tenant is required to give landlord permission for somebody to come in at reasonable times to show new prospective tenants around, and that's in the contract. Whereas the tenant does have the right to refuse entry, it does not mean that that is not a breach of contract. And how this would work in a court would be, if, let's say, hypothetically, over the years, the landlord has always, on average, re-rented the property 2.5 weeks later, and that there's evidence to show this over the last 10 years, properties in this area, I normally get the tenant in 2.5 weeks later. But because of the tenant not allowing the tenant, prospective tenants to come in with the landlord, it then takes an extra month to rent the property as a result of doing that. The landlord could potentially claim a month's rent back in a small claim from the tenant for what's known as loss of opportunity.
So that's very interesting. So yes, that clause doesn't allow you to say, sorry, that clause is in there, so I am entering to do the viewing on those. It does not allow that.
Yes.
What it does put, though, is a liability that if it causes you loss, then they've breached a clause there and you could claim back on that. That's very interesting.
It's consequential financial loss based upon a breach of the tenancy agreement, notwithstanding the fact that the tenant does have that right. It is still a breach of the tenancy because it's a clause in a common law agreement that has been breached by the tenant, even though at law they have the right to do it. The defence for a tenant would be, well, hang on, if I was asked to represent a tenant, I'd say, well, how do we know it might have been it took 7 weeks anyway to let the property, and that's true. That's true. So what a judge will have to do is make a call on how long it would have taken, because there's no certainty that this new tenant moved in.
You'd have to have
it
good
might have
evidence.
happened anyway.
Yeah.
It might have happened anyway. But if the landlord can produce evidence and figures and produce enough evidence on balance of probabilities that he's suffered a financial loss, then I believe a court would award that based upon breach of contract.
Now, our next question is something that we're hearing more and more about, and that's the deed of surrender. And the question we asked was, in which situation might you use a deed of surrender? And it's something that people evidently know quite a bit about, because 93.7% of people got it right, in that it was allowing your tenant to exit a tenancy agreement early.
Absolutely correct, yeah.
And that obviously is the correct way to use it. So could you talk us through how it works and how you go about using one?
Okay, thanks, Polly. A deed of surrender is a very useful mechanism for a landlord who wants to end the agreement with their tenant or tenants in an amicable, consensual way, usually when things aren't working out or the tenant has perhaps got into financial difficulties and wants to move out. The first thing to say is a deed of surrender can be used at any time in the tenancy. So a landlord could hypothetically sign a 2-year tenancy agreement and on day 3 do a deed of surrender and end the entire agreement. It's a very useful mechanism because if a landlord wants possession, then clearly there are clear timelines between serving a Section 8 or a Section 21. This will override all of that. It must be really understood that as a legal mechanism, any landlord could hypothetically go to the property at 6 o'clock tonight if there's an issue and agree with the tenant for the tenant to move out in 2 hours, and if they can pack up and go in 2 hours and sign a deed of surrender and hand back the keys, preferably with a witness because it is a deed, but even without a witness, the argument is it would still stand up, because if 2 people agree something to a contract to which they have both signed and agreed to end it, why should a court say what has happened and agreed between the 2 parties to the contract has not happened? In any event, the handing over of the keys means it's a surrender by action in any event. And if the landlord and tenant agree that without anything in writing, it would still be deemed to be a surrender. Clearly, it's better to have it in writing to protect both parties. So the tenant can't say, the landlord forced me out, and the landlord can't go back to the tenant and say, the tenant has left and there's 5 months left on this tenancy agreement. So it's a very useful mechanism. The other point to say is that a deed of surrender technically is a common law agreement. And a question often asked on the NLA advice line is, well, what happens if there's rent due? What happens with the deposit? What happens if there's a bit of damage to the property? The answer to those questions is that depends upon what you put into the deed of surrender document. For example, and I have done this, where we had a situation where the tenancy wasn't working out, there's been a bit of contention, the tenancy was basically falling apart, one of the tenants had already left, etc. So we agreed a deed of surrender, and as part of the deed of surrender there was a little bit of rent owing, and we waived that. There was a little bit of damage, we waived that, and to get the tenants to agree to go, we agreed to hand back the deposit in full of £500 so that they actually went, and that became a term of the agreement, and the money was handed back and they went, and the tenancy had completely ended. And just to finally, the deed of surrender has the legal effect of severing the legal relationship between the landlord and the tenant. So once the keys are handed back and the tenant vacates and takes their things, they are no longer the landlord, the tenant, and the landlord is no longer the landlord.
And if you've got multiple tenants in the property,
Yeah.
would you need a separate deed for each tenant, or is it does one deed cover everybody?
Right. Even with a joint tenancy, where in normal circumstances, very good question, Polly, and one that does get asked quite frequently, even though it is a joint tenancy, with a deed of surrender, it would require the consent of all tenants. It could all be done on one document. In fact, it's although I can't see any reason why it wouldn't stand up if it was done on separate documents, but best to keep it simple, put everything on one document.
Just put multiple names and get each tenant to sign the document.
The other quick point I just want to make, Polly, is that sometimes a deed of surrender is actually confused with a notice to quit by a tenant. With a notice to quit by a tenant, where it's a joint tenancy, if there are 4 tenants on the tenancy, and one of the tenants only gives a valid notice to quit to the landlord, that ends the tenancy for everybody. With a deed of surrender, it requires the consent of all named tenants on the tenancy. So there is a difference between the two.
Right. Moving on to our final question.
Right.
We're getting to the end,
Yeah.
and this is certainly a question that causes confusion, and it's licensing, which is everyone's favourite topic, I think. And the question we asked was, if your local authority has a selective licensing scheme in place, which properties would require a licence?
Right.
Only 17.1% of people got this right, with the answer being that all private residential rented properties that fall within the district that is subject to the licensing scheme, be they HMOs or single lets. So I think we should probably start by kind of outlining what a selective licensing scheme is, because there's so many licensing schemes now. I think we should probably clarify what selective licensing is.
Right. Selective licensing came into force in 2006, and it basically extends the remit of properties requiring a licence. It often depends upon where the property is located within a particular borough, and licensing schemes are limited to certain types of HMO.
I think it's the scheme that councils. It's not a very widespread type of licensing, is it? It's the one that the councils put into place if they think there's potentially a problem with antisocial behaviour or shortage of well-maintained housing stock, and I think this is the scheme that a lot of local authorities are looking at. Not many are necessarily going for, but they're looking at implementing in certain regions within an authority, within an area, and it can sometimes be just 2 streets, I think. And if a council has noted that a couple of streets within an area have a particular problem with their housing stock, they can put a selective licensing scheme in place to bring that housing standard up. So any rental property, not council rented property, but any private rented property that falls within that postcode of that scheme will then require a licence and let people, the landlords will have to show how they will then handle antisocial behaviour and poor management in those areas.
Yes, I mean, that's quite right, Polly. As selective licensing is introduced, if the council is satisfied that there's problems with low housing demand or significant or persistent problems of antisocial behaviour, which is actually linked to private rented homes. I do know, and I'm aware that apparently it's mainly in the north of England and mainly in areas where the new phrase is there is studentification brought in. It has the effect of widening the class of properties that come within HMO licensing, and once again the property will then come under the remit of the environmental health officer for the local authority. In effect, what it does, it means that the environmental health officer is really, although I've not read this anywhere, it appears that they're kind of co-managing the property with the landlord. And That said, the landlord has to comply with the requirements of the local authority. So it does have the effect of saying that the property will need to have a licence and will come under stricter control in terms of the health and safety requirements and also the policy of the relevant local authority.
And obviously the landlord themselves then have to undergo some testing, the fit and proper person
Correct.
test.
Yes.
And unlike HMO licensing, that there's not as many hoops to jump through for the property as such, but
Correct.
the landlord themselves certainly
Yeah.
do have to
Yes.
undergo the fit and proper person test, which isn't as onerous as it sounds. It's just
No.
checking that you're fit and able to be a appropriate landlord.
Usually it's they do a criminal record check if there's as long as there's no serious offences against the landlord.
Exactly.
Then that usually would be the case. Just to quickly mention that if a property in the area is already under a mandatory HMO, then that is not affected by this.
No.
This is an extra scheme that's been brought in for specific requirements. Yeah.
And there's a great tool, I believe, on the NLA website. NLA Licensing 365, I believe it's called.
Yes,
so
that's correct.
because there's now so many licensing schemes to try and get your head around, and as I say, this could only affect a couple of streets within an
that's
area.
true. Yeah.
So the street next to you
Yeah.
could fall under selective licensing, and your street could be absolutely fine.
Yes.
And I think the NLA Licensing 365 tool, I think you put your postcode of your property in, and it tells you categorically, yes, you need a licence.
Yeah.
No, you don't.
Yes.
Which is really helpful.
That's correct, Polly. We've had situations within an advice line where a landlord has had a specific property requiring selective licensing, and the same property several streets away not requiring selective licensing.
It's useful to double check, and I think you get alerts, don't you?
Yeah.
If anything changes, because they obviously if a council decides that something's changed within, you might need licensing this month and not next month, or vice versa. So it's worth registering with the scheme and just setting up the alerts for your properties.
And we always suggest, if in doubt, just check with the relevant local authority.
Absolutely.
Because one of the issues has been where many local authorities have a limited budget to advertise this, and it's not perhaps often as well publicised as it should be. We also say to our landlords, do double check, use the portal where you can put in a postcode or a specific address, and also double check with the local authority. We will say, if in doubt, contact the local authority just to check.
Definitive answer.
Yes, get a definitive answer. That's absolutely correct.
Brilliant. Well, John, thank you so much for tonight. I feel like we put you through the ringer, I'm afraid, with every type of question from deed of surrender to gas safety.
That's absolutely fine.
Adam, thank you very much for joining us as well, and thank you all for joining us on the line as well. We've got another webinar planned for next month on the always controversial universal credit. Who will be joining us for that one? I'm not sure yet. We're just trying to track down the very best person to help us. I think people are running away from that one with me, so no one wants to talk universal credit with me. But we will track someone down, and further details will be sent out in due course. But yeah, if you'd like to join us for that one, that's next month, and. All the information from tonight will be available on the NLA website and on the Landlord University within the next couple of days. So thank you very much for joining us. John, thanks again. Adam,
thank you.
Thank you for
Polly.
being here, and I hope to see you again soon. Thank you.